Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Welcome to the Virtual Spring Meeting. My name is John Roberti, and today we have a very interesting panel. It is Antitrust and Consumer Protection Ethics Meet ABA Squares. The panel is presented by the Compliance and Ethics Committee. And with me today to give a little bit of context to the panel is Alicia Downey. Alicia is the principal and founder of Downey Law LLC, and she's also the co-chair of the Compliance and Ethics Committee. Hi, Alicia.
Good morning, good afternoon to anyone and everyone who's listening.
So, Alicia, what is this panel about?
Well, this is a presentation in the format of a well-known game show, and the purpose of it is to remind practicing lawyers here in the United States of the requirements of the rules of professional responsibility, that is, lawyer ethics, which is part of the mission of our committee. There's nothing unique about antitrust and lawyer professional ethics, but anybody practicing in this area as a lawyer admitted to practice in any of the 50 states of the United States is subject to a rules regime that is adopted on a state-by-state basis based on the American Bar Association's model rules of professional responsibility. So every lawyer practicing needs to know these rules and needs to know what they require. And there are lots of cutting-edge issues that come up because of changes in technology, changes in the way lawyers interact with clients, and other developments. So at least once a year, every lawyer ought to bring themselves up to speed on how these rules apply in different situations. The game show format is meant to make it kind of fun. There will be hypotheticals presented and a number of special guest celebrities, which is part of the game show format. So although there's only 4 panelists, you're going to see them appear both as themselves and as famous people, dead or alive, from history. And
what are we supposed to get out of this panel?
Well, as I said, it's very important to be aware of the rules and comply with them. Lawyers can be sanctioned here in the United States for violating the rules, even if they do it inadvertently. So with respect to some of the cutting edge issues that are going to be the subject of the hypotheticals that will be presented to the panel, it's important to pay very close attention because sometimes the answers might not be what you think they are.
All right. Well, Alicia, will you stick around and let's watch the panel together, and maybe we can come back and get some of your takeaways. Is that okay?
Sure.
Okay. With that, let's send it over to Doug TWEEN and the group that is doing the ABA Squares.
Hello, everyone, and welcome to ABA Squares, Antitrust Style, featuring special guests, Trish Connors, Eric MEIRING, Patrick THOMPSON, and Danielle HAUGLAND, with the Not Ready for Spring Meeting players, and your host, Doug TWEEN.
Hello, everyone, and welcome to ABA Squares Antitrust Style. This exciting, challenging, and humorous game show will examine the application of the model rules of professional responsibility to ethical questions confronting antitrust and consumer protection lawyers. You all know the rules. Like the game of tic-tac-toe, our contestants pick a square, our celebrity gives an answer, and then the contestant agrees or disagrees. The contestants get an X or an O in the box for every correct answer. Get 3 in a row, and you could win a fabulous prize. I'm Doug TWEEN, a partner at Linklaters in New York and Washington when I'm not hosting game shows. First, let's meet our contestants. Rachel Dalal is a paralegal from New York, and Amanda Griggs is an attorney, also from New York. And now let's meet our panelists. Some of them need no introduction to this audience. They are the Rosemaries and the Paul Lynns of the antitrust bar. Trish Connors is Chief Associate Deputy Attorney General under Florida Attorney General Ashley Moody. She oversees the antitrust and complex enforcement, consumer protection, lemon law, arbitration, and civil rights divisions of the office and oversees all major enforcement matters handled by those units. In addition to her general management responsibilities, Trish continues to serve as the director of the Antitrust Division for the Florida Attorney General's Office, where since 1995 she's been responsible for implementing and overseeing the AG's state and federal antitrust enforcement efforts. Danielle HAUGLAND is a seasoned lawyer and legal services transformation consultant at alternative legal services provider Integreon. Danielle consults with law firms and corporate law departments on the implementation of legal process innovation, enabling technologies, and alternative resourcing. Danielle supports her clients in mitigating risk and driving operational efficiencies across multiple legal practice and functional areas, including discovery, contracts management, e-billing, legal spend management, and compliance. Before diving into the world of legal innovation, Danielle was an antitrust and commercial litigator at DLA Piper and King & Spalding. Eric MEIRING is an antitrust and white-collar partner in the Washington office of Winston Strawn. Prior to joining Winston, Eric spent 10 years at the U.S. Department of Justice Antitrust Division, where he served as an acting chief and assistant chief in one of the Washington sections. His practice is focused on representing companies and individuals in complex government investigations and high-stakes criminal and civil litigation. And Patrick Thompson is a partner in the San Francisco office of Perkins Coie. He has spent more than 2 decades representing clients facing federal and state antitrust claims and defending consumer protection class actions. Patrick's litigation background includes arbitrations, trials, and numerous summary judgment victories for a range of sector-leading clients. And now let's go to our game. Okay, Amanda, you're the X, so pick a square.
Thanks, Doug. I think to start off, I'll choose Eric in the top left.
Okay, let's go to our first clip featuring an excerpt from the movie Legally Blonde, as performed by the Not Ready for Spring Meeting players.
Elle and her friend Paulette have gone to the trailer of Paulette's boyfriend, Dewey, to take back Paulette's cat.
You ready?
No.
Yes, you are. Go on. You can do this.
Yeah, just a sec. I'll see who's here. The hell do you want? Trying to have lunch here.
I just thought that,
You just thought you'd come over and show me what I'm definitely not missing.
that's not why I came by.
How many times are you going to show up here begging me to take you back?
Dewey Newcomb?
Who wants to know?
I'm Elle Woods, Ms. Bonafante's attorney, and I'm here to discuss the legal situation at hand.
Come again?
Do you understand what subject matter jurisdiction is?
No.
Yeah, I didn't think so. Well, due to habeas corpus, you and Miss Bonafante had a common law marriage, which heretofore entitles her to what is legally referred to as equitable division of assets.
Excuse me?
Due to the fact that you retained this residence, Ms. Bonafante is entitled to full feline property ownership and will be enforcing said ownership right now.
Huh?
You tell him, Paulette.
I'm taking the cat, dumbass.
Okay, Eric, did Elle Woods act ethically or unethically?
And I certainly think that Elle is going to learn the hard way that orange is in fact the new pink. And I hope she enjoys her new jumpsuit, but I think I'm going to go with unethical.
Amanda, do you agree or disagree?
Doug, I think I'm going to agree. I think she acted unethically.
That's correct. Eric, explain to us why that answer is correct.
Well, the prevailing ABA model rule that is involved here is Rule 4.3. And what happened here is you have Elle, who is representing an individual and doesn't tell the other individual who is not represented by a counsel that she's a disinterested party. Instead, what you have here is her holding out and allowing the other person to misunderstand her role in the matter. And the lawyer in this case did not make reasonable efforts to correct that misunderstanding, which is in violation of Rule 4.3, which is you can't give legal advice to an unrepresented person other than to tell them that they need to find their own lawyer. Obviously, the other issue here is with Elle is under Model Rule 5.5, the unauthorized practice of law, because at this point, Elle is not yet a lawyer and is not barred in that jurisdiction, and lawyers cannot hold themselves out to represent clients in jurisdictions where they are not barred. And in fact, this case, she is not barred at all. So she cannot hold herself out as a lawyer because she has not passed the bar.
Okay, thank you for that explanation. That's correct. So X gets the square. Okay, let's go to our next question. Rachel, your turn to pick a square.
I think I'll choose Trisha's square.
Okay, great choice. And here's the question. Attorney Jack Bond is running late for his JFK to Heathrow flight to attend an important client meeting across the pond. Sprinting through the terminal, he gets held up at security when a TSA agent asks to search his laptop, which contains confidential client information. Jacques sighs, opens the laptop, and types in the password, hoping that his cooperation will get him to the gate on time. Trish, did Jacques act ethically or unethically?
Of course it's ethical. The plane's not going to wait for the guy. It's TSA. It's not like he's in some public place on some Wi-Fi. You go into TSA, you get poked and you get prodded, and they look in every crook and cranny, and so it's reasonable to expect that they're going to be asking for stuff like this, and so he has to give it to him. What if it's in an appointment where the client's representation might be compromised if he's not there? He's got to get on that plane. So I think what he did was ethical.
Okay, Rachel, do you agree or disagree?
I'm going to have to disagree. I think he acted unethically.
That's correct. Trish, that was not much of an answer. Maybe we're going to ask you to try and explain to us why that was not the correct answer.
Now, of course, it was not the correct answer, and the real answer is that giving up your password even at a TSA gate or a border crossing, which is where some of these opinions are based, is unethical. And even in this scenario, Jacques was obligated to take every reasonable effort to protect information. In this hypothetical, he doesn't make any effort as he rushes off to catch his plane. The operative rule is ABA Model Rule 1.6 regarding an attorney's obligations as to the confidentiality of client information. It mandates that an attorney must not reveal information relating to the representation of a client unless he has the client's informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted under 1.6b. That exception would allow a lawyer to review information relating to his representation if the lawyer reasonably believes it is necessary. Here, none of that pertains. The client did not give his informed consent. The disclosure was not impliedly authorized. And I don't think the prospect of missing a plane would be enough for the lawyer to believe disclosure under this circumstance would be warranted. So once a lawyer has client information in his possession, he always has the duty to make reasonable efforts to prevent the inadvertent or undisclosed disclosure of or unauthorized access to information relating to the representation of the client. And then 2015 New York City Bar Ethics Opinion was issued to lend some guidance on that. The opinion says that the letter should first inform the agent that the device contains privileged and or confidential information, request that the material not be searched or copied, ask to speak to the agent's supervisor or make any other lawful request to protect the information. And if the device is searched, the lawyer is required to timely inform all affected clients. And then the opinion also goes on to provide other guidance to consider before you even leave for a trip. So it's a good opinion to review before you take on any international travel of any kind. The one other thing I would note is that some state ethics rules also require lawyers to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So in some states, there's an expectation that lawyers are staying on top of changes in technology in order to protect client information.
Okay, thanks, Trish. And circle gets the square. So let's move to our next question. Amanda, back to you to pick a square.
Thanks, Doug. I think for this time, I'll try Patrick in the lower left.
Okay, Patrick, here's your question. Jeff Budman Dawson wants to cultivate medical marijuana for personal use and sale to others. He seeks the advice of local attorney Richard MEIRING. Because recreational marijuana is legal in their state, Richard offers to help Jeff set up his business. Ethical or unethical?
Doug, I'm feeling a little parched. Business is blazing. It's out here in California. Of course it's ethical. We allow for recreational use of marijuana out here. And I think Amanda's from New York. They toke up there too.
Okay, Amanda, do you agree or disagree?
I would have to think in these modern and progressive times that I would tend to agree. It's ethical.
I'm sorry. The answer is not correct. What law school did you say you went to? Patrick, explain your answer to us.
Here's the explanation. We know that the coasts are not where the rest of the country is. Under the ABA model rules, 8.4b, it prohibits a lawyer from committing a criminal act. Based on that, and because under federal law, marijuana is still a controlled substance, it's possible that Richard acted unethically. It's very important with this particular area to look at state laws because state laws vary, and the particular view that the state bar or state board of professional conduct is going to take with respect to this type of counseling is going to depend. There are opinion letters in New York, there are opinions across the country, but it's a patchwork landscape. The other thing that you have to consider is where is Richard advising the client to do business? If there are things in interstate commerce, Richard could be doing an enormous disservice to the client. And so in this circumstance, you are entitled to advise the client about the existence of state laws and what those laws are, and counsel about what those laws, what the basic parameters are, but you have to be very, very careful about doing anything that could be perceived as aiding a criminal enterprise, which, unfortunately, Amanda, outside of New York and California, it may be in the vast in-between that the rules and the landscape are not the same, and so potentially acted unethically.
So I'm afraid no one gets that square. Rachel, it's your turn to pick a square.
I'm going to pick Danielle's square.
Okay, Danielle, here's your question.
All right.
Partner Bill Nixon just got a free demo from Nimbus, a cloud-based storage system for client files. To help get rid of some desktop clutter, he uploads a large client file. Talking later to an associate, the associate asks, Mr. Nixon, did you just share confidential client information with a third party? Mr. Nixon has no idea. Danielle, did Mr. Nixon act ethically or unethically?
All right, so I'm not sure what this Mr. Nixon was thinking, but of course you cannot do this. Firms must keep all client files on paper, stored in their physical offices, where attorneys must go out of their homes and access them. So, unethical.
Rachel, do you agree or disagree?
I think it's totally unethical.
That's right. Danielle, explain that answer to us.
Well, it's a bit of a mixed bag, actually. According to Model Rule 1.6a, using cloud-based solutions is ethical so long as you do your due diligence on the vendor to ensure that client information is kept confidential. So this is actually becoming more of the rule versus the exception these days. And this is exciting, really exciting, because it allows for new entrants in the legal technology space to scale quickly. So services like Kira Systems and Seal and iCertis, which are all have a cloud-based component to them or offer a cloud-based service, they're contract analytics tools. Those are gaining traction and are really exciting. Services like Clio, which is a practice management platform, which is, I think, almost exclusively in the cloud, that's gaining traction as well. And this is pretty exciting for the legal space. A few courts have addressed the issue and advised that common sense plays a big role here. So things like reviewing cloud computing industry standards and familiarizing yourself with appropriate safeguards. Investigating the cloud provider, whether they have implemented reasonable security precautions to protect client data. Investigating the provider's reputation and history. So in the example given, maybe a fly-by-night vendor offering a free trial is not the best idea, but using a reputable and established cloud service probably would be okay, so long as you use basic common sense to ensure that your client's information is maintained confidential.
Okay, X gets the square. Amanda, it's your turn again to pick a square.
Thanks, Doug. I think I'll go with John Sherman this time.
Okay, time for another clip from Legally Blonde as performed by the Not Ready for Spring Meeting players.
In this scene, Elle is defending a prominent fitness instructor named Brooke Wyndham, who is accused of murdering her husband. Elle is cross-examining Brooke Wyndham's stepdaughter, Chutney Wyndham.
Wyndham, what had you done earlier that day?
I got up, got a latte, went to the gym, got a perm, went home.
When you got into the shower.
Counsel, I believe the witness has made it clear she was in the shower.
Yes, Your Honor. Ms. Wyndham, had you ever gotten a perm before?
Yes.
How many would you say?
2 a year since I was 12. You do the math.
Yeah. A girl in my sorority, Tracy Marcinko, got a perm once. We all tried to talk her out of it. Curls weren't a good look on her. She didn't have that good bone structure that you have. But thankfully, that same day she entered the Beta Theta Pi wet t-shirt contest, where she got completely hosed down from head to toe.
Jackson, why is this relevant?
Oh, I have a point, I promise.
Then make it.
Yes, Your Honor. Chutney, why is it that Tracy Marcinko's curls got ruined when she got hosed down?
Because they are what?
Exactly. Because isn't it the first cardinal rule of perm maintenance that you are forbidden to wet your hair for at least 24 hours after getting a perm, at the risk of deactivating the ammonium thioglycolate?
Yes.
And wouldn't someone who's had, say, 30 perms before in her life be well aware of this rule? And if, in fact, you weren't washing your hair, which I suspect you weren't, because your curls are still intact, wouldn't you have heard the gunshot? And in fact, you had heard the gunshot, and had you, Brooke Wyndham wouldn't have had time to hide the gun before you got downstairs, which would mean that you should have had to find Ms. Wyndham with a gun in her hand to make your story plausible. Isn't that right?
She's my age. Did she tell you that? How would you feel if your father married someone who was your age?
You had, however, time to hide the gun, didn't you, Chutney? After you shot your father?
I didn't mean to shoot him. I thought it was Brooke walking through the door.
Order, order, order.
Oh my God.
Oh my God.
Oh my God. Bailiff, take the witness into custody, where she will be charged for the murder of Hayworth Wyndham. In the matter of State versus Brooke Wyndham, this case is dismissed. Mrs. Wyndham, you are free to go. Counsel, how did you know Chutney was lying?
Because she's brilliant, of course.
The rules of hair care are simple and finite. Any Cosmo girl would have known.
Okay, Senator Sherman, did the partner act ethically or unethically?
Well, I have to say that my wife sure loves Elle Woods, and even though I'm playing the great John Sherman from the great state of Ohio, I don't think I can go against Elle twice, so I'm going to say she acted ethically. Both the judge and my wife are always right, and I've learned that a long time ago, so I'm going to go with ethics.
Amanda, do you agree or disagree?
I'm going to have to agree.
That's right. Senator, explain to us that answer.
In this case, Elle acted ethically, at least arguably ethically. Again, she's not a practicing attorney yet. She's still in law school. So there's, when she's practicing law, there's a potential violation here of the legal professional rules of conduct in Massachusetts, which only allow for representations by senior members of law schools. And in this case, she's a first year. And then that person also has to have successfully completed or enrolled in a course related to evidence and trial practice, and also obtain written approval from the dean of the law school about that person's character, legal ability, and training, and must also appear without compensation and on behalf of an indigent defendant in a criminal proceeding. That all goes from Model Rule, ABA Model Rule 5.5 as well. And so in this case, one could argue that she's acting unethically because obviously this isn't an indigent defendant, and she's only in her second year or first year of law school. That being said, with the Massachusetts Supreme Court case on point at 3.03, and the fact that the judge has okayed all of this situation, it's really hard to say that anything Elle did in this case would be unethical.
Circle gets the square. Rachel, your turn to pick a square.
I'm going to pick Kim Kardashian's square.
Of course, the famed ethics expert. Okay, Ms. Kardashian. Early on in the investigation of a large multinational company, FBI agents Butch and Sundance went to the home of Harvey Logan, VP of Sales, who felt very intimidated and spoke with the agents for several hours. On the way out, Agent Butch turned to Sundance and said, "Wait, was that ethical? What if he was represented by a lawyer?" Doesn't the company have a general counsel? So, did Butch and Sundance act ethically or unethically, Kim?
Oh, I don't know. I've been doing this, for a long time, but I'm not sure. God, I hope I get it right. This would be embarrassing. Oh my God. I'm gonna say, probably ethical. He's a VP. Those are a dime a dozen in corporations. So he's not upper management. He's not represented by his own counsel. There's nothing that really should say that the corporation should represent him in the general counsel of the corporation if there is one. And I don't think so. I think he's okay to be talked to by the agent. Okay.
Kim, I assume you have plenty of experience with law enforcement. So Rachel, is she right or wrong?
I think she's wrong. I think it was unethical.
Oh, I'm sorry. Kim, explain that answer.
So the real answer is that the agent's conduct is ethical because, as I said, Mr. Ligon was not represented by counsel. There's no obvious evidence indicating that he was represented. And so as a general rule, just because there might be a general counsel who's an attorney for the corporation, they don't represent the employees just automatically. The ethics rules generally prohibit ex parte contact with current employees of a represented organization who either are high-ranking, meaning executive level employees who make binding decisions on behalf of the corporation, or were directly involved in taking actions against a particular client, so your client. So jurisdictions do vary on some of this, but you generally are permitted to contact former employees and current low-ranking employees without first consenting, getting the consent of the organization's counsel. So the rule that pertains is ABA Model Rule 4.2. It deals with communications with persons represented by counsel, but the comment there alludes to representation in other ways. And comment 7 to the rule states that in the case of a represented organization, Rule 4.2 prohibits communication with a constituent of the organization who supervises or directs or regularly consults with the organization's lawyer concerning a matter or has the authority to obligate a corporation with respect to a matter, or whose act or omission in connection with the matter may be imputed to the organization for some civil or criminal liability. If the constituent of the organization is represented in the matter by his own counsel during that time, the consent by that counsel to communication will be sufficient for purposes of the rule. So here we have FBI agents who visited a current mid-level managerial type employee who does not appear to be one who falls within the description of the higher level employees in the comment. The agents weren't obligated to ask if he was represented, and the employee didn't say that he was, apparently did not ask for a lawyer or to consult with a lawyer. So they could proceed with the interview, even if the employee felt intimidated, and so he cooperated by answering questions for hours. It's pretty well settled that the general counsel of the corporation the employee might work for doesn't automatically represent any employee. So the fact that the corporation had in-house counsel does not mean that the counsel should have been contacted before the interview. Additionally, the fact that these agents were agents and not lawyers doesn't change the fact that they are agents for the prosecuting attorney. So it's an end run around the requirements of Rule 4.2 when a person is known to be represented by another lawyer to have your agents make the contact instead of the actual lawyers.
Okay, thanks, Kim. No one gets that square. Amanda, your turn to pick a square.
Thanks, Doug. I think in an effort to redeem myself, I'm going to try Patrick again.
Okay, it's time for one more clip, this time from the movie Liar Liar, as performed by the Not Ready for Spring Meeting players.
Wow, this is good. This is really smart.
Thank you.
Only, well, it's not true. Does that present a problem?
Mrs. Cole, the only problem here is that after you've provided years of faithful service, of loving support, raising his children, they are his.
Yeah, one for sure.
After all that, your husband wants to deny you a fair share of the assets based on one single act of indiscretion.
Well, 7.
Pardon me?
7 single acts of indiscretion.
7 acts of indiscretion, but only one of which he has any evidence of, and all of which he himself is responsible for.
He is?
Mrs. Cole, you are the victim here. The wife of a cold, distant workaholic, starved for affection, driven into the arms of another man.
Well, 7.
Yeah, whatever. You're not trying to deny him what is rightfully his. All you're insisting on is what is rightfully yours.
Yeah.
And maybe a fraction more. I think you're bending over backwards.
Yeah, I did offer to give him joint custody of the kids. He is, after all, a wonderful father.
And how does he repay you? By dragging you through a painful litigation process.
Oh, thank you. I am so grateful to have an attorney I can trust.
Patrick, did the partner act ethically or unethically?
Well, I'm glad that Amanda reposed confidence in me because this is about redemption. This is what, even with that dramatic display, it is clear. What he did is unethical.
Amanda, do you agree or disagree?
I agree. It seems unethical.
That's right. Patrick, explain that answer to us.
Redemption! It is unethical because lawyers have an obligation to tell the truth. This is a consumer protection panel. Ethics around misrepresentation. Lawyers have to adhere to the same rules. A lawyer shall not knowingly make a false statement of material fact or law. You can't do it. ABA Model Rule 4.1 applies. Even though we're supposed to be zealous advocates, we are also officers of the court. That binds us to tell the truth. What you saw even in that attempt at drama was someone who gave lawyers a bad name because we are known for twisting and churning the truth. That's not what we're supposed to do. We're supposed to be truthful, and we're not supposed to knowingly make misrepresentations. That does not mean we have this affirmative duty necessary to disclose every single possible fact, but the basic bottom line, bright line rule is that a lawyer is required to be truthful when dealing with others.
Okay, thanks, Patrick. X gets to the square. Rachel, your turn to pick a square.
Thanks, Doug. I'm gonna choose Robert Bork this time.
Okay, here's the question. TechAlways Technologies, Inc. is one of the largest tech companies operating in the U.S. that's been hit with a class action lawsuit for intentionally shutting off older devices to get customers to upgrade. TechAlways, trying to save money and be efficient with its resources, hires ABC LLP to handle its legal strategy and most of the trial work. They also hire an alternative legal service provider, Class Act, to handle much of the fact investigation and organization, including document review, deposition prep, case mapping, witness kits, etc. TechAlways' GC, Stephen Labor, wonders if this is ethical under current ABA rules. Judge Bork, is this ethical or unethical?
Thanks for the question. Bit of a self-serving answer here as, my colleague Danielle HAUGLAND, but of course I'm Judge Bork, works for an ALSP that does this work all day, every day. I'd say, yeah, post ethical.
Do you agree or disagree?
I'd agree. I think it's ethical too.
That's right. Judge Bork, explain your answer to us.
Sure thing. So this is actually a hot topic in legal innovation circles, and there are two primary concepts at play here. First is the unauthorized practice of law, that's Model Rule 5.5. The second is non-lawyer ownership and sharing of fees, Model Rule 5.4. So the unauthorized or the UPL issue is actually pretty easy to take care of. None of the work that law companies or ALSPs currently handle, for example, document review, that's a really simple one. Fact development and mapping is considered the practice of law. And in any event, we operate or they operate at the direction of counsel, either in-house counsel or outside counsel. The trickier bit relates to Rule 5.4, dealing with ownership. And this is where it gets really interesting and takes a bit of a social bend. Access to justice is an issue in the United States. There are huge swaths of people that have everyday legal issues, from divorce to small business incorporation to minor criminal matters that they go forward alone without legal representation. This is where tech startups, legal tech startups enter. Tech startups like Hello Divorce and LegalZoom. At the other end of the spectrum, you have companies like the Big Four and ALSPs that are eager to expand the range of services that they provide. And these two factions at the end of these spectrums have formed an alliance of sorts to lobby for ethics reform that would allow non-lawyer ownership of entities that provide legal services. It's a slow-moving train, but there's some momentum. Some states are forming committees and task forces to explore the issue. And the ABA notably adopted Resolution 115 a few months ago, encouraging such exploration, but it did not recommend actually changing rules. Go figure.
Okay. Thank you, Judge. Circle gets the square. Amanda, your turn to pick a square.
Thanks, Doug. For this round, I'm going to choose Cicero.
Cicero. Interesting choice. Okay, Cicero, here's the question. Attorney Wilmer Font has a client whose bill was in arrears. One day, the client's father came to Wilmer's office with a check, asking him to put the money towards his son's bill, but to do it anonymously. Wilmer gratefully deposited the check and applied it toward the balance without saying a word to his client. Cicero, did Wilmer act ethically or unethically?
Well, I think Cicero is very excited not to have a question involving Elle Woods. I think that's where he would definitely start. And it's so hard to turn down money during the pandemic for all of us lawyers out there. And typically fathers know best, but not here. I'm going to say unethical.
Okay. Amanda, do you agree or disagree?
I'm going to disagree. I think it was ethical.
Oh, I'm sorry. That's not correct. Explain to us that answer, Cicero.
Wilmer didn't act ethically because an attorney can only accept compensation or payment for his legal or her legal services from someone other than a client with the client's actual consent. And this is a really good one for antitrust lawyers because it's something that comes up with some level of regularity, especially if you're involved in joint defenses or indemnification issues, or you represent individuals in criminal antitrust matters where their fees are often indemnified by the parent corporation or the corporation itself. And there is actually a third party making payments to the lawyer on behalf of that individual. And in those cases, the issue is governed by ABA Model Rule 1.8c, which involves conflicts of interest for current clients. And that says that a lawyer cannot solicit substantial gifts from a client and cannot accept payment from third parties without approval of that client itself. And so in most of these cases, an attorney is permitted to accept compensation from someone other than the client if the client approves and the third party doesn't interfere with the independence of that attorney. In that sense, you can't lose your professional judgment and start to take positions that might be contrary to your actual client. You need to make it clear to both the client and the entity or individual through which you're accepting payment that the client has all of your interests and all of your work is towards that client. And if for some reason the individual or the entity making payments in this instance actually interferes with that attorney-client relationship, then you can't take that payment from the third party. And then the last piece that the model rules say is the attorney does not reveal confidential information to the third party. So in this instance, you couldn't reveal confidential information about the client's case, or any other information related to the client confidence with that father, or in antitrust circles, with the parent, the corporation, or whatever entity has indemnified your client.
Okay, thank you for that answer. But I'm sorry, nobody gets that square. Rachel, it's back to you. The square.
I'm gonna go with Kim Kardashian again.
Okay, Kim, here's the question. The client hired defense attorney Ken White for a complicated RICO case. Ken said, it's never RICO, and agreed to do the work. Ken's associates did extensive legal research, prepared numerous legal memos of fact and law, and drafted most of the court documents. But the client became frustrated and fired Ken. Surprisingly, very surprisingly in my experience, the client paid Ken for the work, but also demanded that Ken turn over all documents. Ken refuses. So Kim, did Ken act ethically or unethically?
Well, I would say, first of all, I just shook the FBI agents, and now you're telling me I'm dealing with RICO? For God's sake. Are you kidding me? Anyway, the client can't have his cake and eat it too. Either he is sticking with the lawyer or not, and if not, the lawyer can hold back the materials prepared in the course of the client's representation. So, I think that what he was doing is ethical. Once the client paid him and fired him, that was it. And the attorney's obligation to the client ended with that representation being terminated. That's it. End of story. Otherwise, where's it going to end? Rachel?
Do you agree or disagree?
I'm going to disagree. I think it was unethical.
That's correct. Good job. And my advice to you is never take your legal advice from Kim Kardashian. Kim, explain to us why that was unethical.
Well, it was unethical because the lawyers refused to turn over all the documents. When he's been fired, would violate ABA Model Rule 1.16e, which in fact requires him to return all papers and property to which the client is entitled. So generally speaking, that means that the client is not entitled to papers and property that the lawyer generated for the lawyer's own purpose in working on the client's matter, like internal research memos. But when the lawyer's representation of the client is terminated before the matter is completed, protection of the former client's interests may require that certain materials the lawyer generated for the lawyer's own purpose be provided to the client. 1.16d states that when representation is terminated, a lawyer has to take those reasonable steps, whatever is reasonably practicable, the rule states, to protect the client's interest, including surrendering papers and property which the client is entitled to, and refunding even any advance payment or fee or expense that has not been earned or incurred. And the rule does provide that lawyers may retain papers relating to the client to the extent permitted by other law, quote unquote, other law. The majority rule on this issue for most states is that upon termination, an attorney must surrender all papers and property related to representation of the client unless there is some specific exception under state law. Then there's a minority rule, which is called the end product rule. And it says that upon termination, an attorney must surrender only the end product of the attorney's services, but need not turn over the materials that were used to create the end product. An operative opinion here is Formal Opinion 471 from the ABA from 2015 that opined that the end product approach is the minimum required by the ethics rules. You can't simply keep everything and not turn it over. In the ABA opinion, there was a lawyer representing a municipality for about 10 years under a contract for legal services. When the contract expired, they ditched the attorney and wanted to get somebody new, and requested that the lawyer provide the new firm with all the materials that the terminated lawyer had from both open and closed matters. So the discharged lawyer asked for an opinion. The ABA opinion stated that at a minimum, the attorney had to turn over any materials provided to the lawyer by the municipality. So legal documents filed with tribunal or completed and about to be filed, court orders or other such records, correspondence between the lawyer and others, including emails, discovery, exhibits, transcripts of that nature, legal opinions issued when the municipality requested it, and third-party assessments or evaluations or records paid for by the municipality. And then the opinion goes on to say that there may be circumstances in individual representations that require the lawyer to provide additional materials related to the representation, and gives some, as an example, the situation where a lawyer has been terminated before a matter is concluded. The protection of the client's interest in that instance may require the lawyer to provide the client with paper or property generated by the lawyer for the lawyer's own purpose. So in that situation, the lawyer may have to release at least some of the materials that were generated internally within the law office for the lawyer's own personal use. For example, his internal notes and memos generated by others within the firm. And so in this hypothetical, the client is entitled to all the papers the lawyer has prepared. And it should be noted that under the law of many states, at least in states that have addressed the issue, an attorney can assert on a lien on client papers in his or her possession to secure the payment of a fee. But here, that's not an issue because the client had already paid the attorney to do the work.
Okay, thank you, Kim. And circle gets the square. Amanda, your turn to pick a square.
Being that Rachel seems to have me in a lose-lose scenario here, I think I'll just stick with Cicero and try to go out on a high note.
Okay, Cicero to block. Here's the question. Attorney Emma was representing Ant-Man Enterprises in a termination dispute with a disgruntled former employee. During a deposition, AME CEO Paul Rude was asked when AME was founded, and he responded, "In the year none of your business." Opposing counsel, exasperated, looked at attorney Emma, who sighed, I know. I've tried to tell him he can't behave like this before, after he did the same thing to his wife's divorce attorney." So Cicero, did attorney Emma act ethically or unethically?
Well, waxing philosophically about this, I think year none of business is around the era of Cicero. I think that if we look at our classical underpinnings, this is clearly unethical behavior.
Do you agree or disagree?
That was very persuasive, so I'm going to tend to agree.
That's right. Stick with Cicero when it comes to philosophical answers, I think. Cicero, why don't you explain to us why you came out that way?
Doug, I think it is challenging to ask Cicero to expound, being the rhetorician he is. But here it is clear that ABA Model Rule 1.6a applies. Even though Emma is obviously exasperated by her client, and we have been there, there's a rule that requires us to ethically represent our client and not disclose any confidential information relating to the representation of the client. This is information related to the representation of the client, and when Emma says he's behaved like this before, and this happened in the case with his wife's divorce attorney. In divulging that information, I understand Emma's tired. I understand that lawyers like to have these witty repartees on the record in a deposition to kind of break the ice. But it's not fairly representing the client when you reveal information that's confidential, and you can't do it without getting the client's informed consent. The appropriate thing would be for Emma to break his sidebar, to consult her client, and ask the client to simply answer the questions. It is not ethical. It is not appropriate for Emma to share her perspective informed by confidential information the client relayed to her as the client's attorney. And so it is unethical under ABA Model Rule 1.6a.
Okay, thank you, Cicero. And X gets the square. Rachel, your turn to pick with a chance to win the game.
I am gonna choose Adam Smith.
Okay, Mr. Contrivance against the public. Here's the question. Attorney Kevin Birch is tired of clients who won't pay their bills and adds a clause to his representation agreement allowing him to withdraw if a client fails to pay on time, so long as he gives reasonable notice. Kevin's contract specifically allowed the client time to consult with another attorney before signing it. Is that ethical or unethical?
Well,
Yeah. Instead of the lawyers representing the Tiger King, which they would have known this a while ago, but yeah, it's ethical.
Okay, Rachel, for the win.
I'm going to agree. I think it's ethical.
That's right. And Adam, Mr. Merriment, explain to us your answer, please.
Sure thing. So it's Model Rule 1.16, and that states that declining or terminating representation is ethical if the client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's service and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled, which attorney Kevin Birch did. Although the agreement gives the client notice of the possibility of withdrawal, the attorney would still need to give the client notice that she was going to invoke the clause because the client would need time to seek new counsel. Keep in mind, though, that the attorney may need to obtain permission of a court before withdrawing, but in any event, or in all events, the attorney must take steps to protect the client's interests at all times.
Okay, so Circle gets the square, and we have a winner. Congratulations, Rachel, and you'll be thrilled to know that your prize new copy of Antitrust Law Developments will be on the way to you any day now. Congratulations to our players, Rachel Dwell and Amanda Griggs, the Not Ready for Spring Meeting players, and special thanks to our celebrities, Trish Connors, Patrick Thompson, Danielle HAUGLAND, and Eric MEIRING. I'm your host, Doug TWEEN, reminding you to always be ethical and be sure to tune in to the rest of the virtual spring meeting. So long from Hollywood, this is ABA Square.
Okay. Welcome back, I think. Alicia, you are still with me, I hope. What'd you think?
Well, that was a wild ride in a pretty unusual panel, thanks to this online format. I hope people enjoyed it. I know I did. You know, I made some notes along the way about 4 issues that the panel talked about that I think really do exemplify how the rules need to be interpreted to apply to some very sort of modern questions.
first one that I flagged was the protection of confidential client information in scenarios in which you may be at an airport and authorities are demanding to search your laptop, perhaps look through your briefcase, demand the password for your password protected devices. And the fact that that does potentially expose confidential client information, what is the lawyer supposed to do in that situation? And I thought it was great that the panel referred to some very specific resources and an ethical opinion that lawyers can consult in advance of being presented with that kind of a dilemma. The second issue I thought was very interesting was what the lawyer's duty is with respect to advising a client and assisting them in creating a business, specifically a cannabis business, that is compliant with state law, but that may be illegal under federal law. There again, the lawyer has to be extremely careful and avoid crossing the line into a violation of the rule against the lawyer actively assisting in the perpetration of a crime. Another issue I thought was what lawyers need to do with respect to the protection of confidential client information and other materials, perhaps even their email system, that when they store that data in the cloud, that is, it's not physically located in the lawyer's locked office anymore. It is being stored by a third party, and sort of what the lawyer's duty is to undertake sufficient diligence to make sure that the client's data is protected when stored in that form. And finally, this is also a very hot topic, one that the ABA itself has been contending with, and that is the role of some legal tech service providers and other websites, for example, and when their activities cross over into the unauthorized practice of law, it may seem clear that a service that simply analyzes documents or performs other functions under the supervision of an attorney or at the direction of an attorney may be less of a risk. But what about the services that are trying to provide access to justice, that is affordable legal assistance for people who simply cannot pay for a lawyer? And that with it comes the question of the ownership of law firms by non-lawyers, which the model rules and the rules of the states tend to prohibit. There are a number of developments that could happen on that front. The ABA has at least, I believe, decided that it's willing to look at these issues and possibly revise the rules in the future. But it seems like the trend is clear. There will be more pressure for companies to offer these services, and it's just a question of time, I think. But the rules of professional responsibility and the lawyer's role in these services is definitely something that's going to evolve.
Alicia, thanks for that. And I think it was in a somewhat fun, silly package, but there's a lot of really important information that's in there. So thank you for helping us to pull this out, and I hope folks can take these very important points away. Alicia, you are the co-chair of the Ethics and Compliance Committee at the Antitrust Law Section. Can you tell us a little bit about what your committee does and how folks can get involved?
Oh, sure. Well, my current co-chair is an economist based in Mexico City, Eduardo Perez Mota. And he and I, over the past year, have continued the committee's mission to really promote the study of compliance programs and compliance technology within the section. We have produced a number of special newsletters over the last 2 years that focus on compliance technology, such as artificial intelligence and blockchain technology and smart devices, the Internet of Things. But we also interact with many other committees on such developments like the Department of Justice's rollout of guidance with respect to the manner in which it will evaluate corporate compliance programs in its charging and sentencing recommendations. That was an important development over the last year that we did a telephonic program about, probably within a week or two of the guidelines issuing. So we're very much, we'd like to serve as a clearinghouse for information about compliance programs, obviously antitrust compliance programs being the primary focus. And our biggest accomplishment this past year was the publication of a massive book, comprehensive guide to antitrust compliance programs called the Antitrust Compliance Handbook, A Practitioner's Guide. And this is going to be the Bible for in-house counsel charged with antitrust compliance, and also for compliance professionals who may not know enough substantive law about antitrust and need to understand how that information can be incorporated into either existing or proposed corporate compliance programs. So it's a great publication. Many, many authors contributed to it. So I recommend people check that out.
Great. Thank you, Alicia. And again, really important stuff, really great stuff going on in your committee. Before we depart, I do want to ask you a couple more questions about the video. I don't know if you saw Doug TWEEN's shirt. Do you think he bought that specially for the video, or do you think he had that and wears that around sometimes?
I think he keeps it in his closet and takes it out whenever it's appropriate.
Like whenever he's about to do a mock game show?
Yes. Yes.
I'm just trying to think when another time where that could be appropriate. And I don't know if, do you think people will recognize that those weren't actually the celebrities? We didn't have them on. I think we used pictures or something. People were going to figure that out.
Well, the special effects in this video are really something, yeah, that was really realistic.
I think you probably would not have gotten the same level of special effects at the the in-person spring meeting. So at least we have that going for us.
Yeah, I mean, we missed the fun of the live performance. I do think the panelists all did a really good job, as did Doug in his shirt. I'm glad he brought a little color into our lives at this very strange time. But as you said before, if you look under the surface of all the silliness, there was an awful lot of content there. And I know the panelists worked very hard to prepare for the presentation, as did the young contestants too. They did a great job as well. All
right. Well, great. Well, thank you, Alicia. Thank you for coming on. I do want to thank Doug TWEEN, all of the panelists, all the folks who contributed to this, the Not Ready for Spring meeting players, everyone who worked very hard to put this meeting together. As Alicia said, there's a lot of really good information packed in a package that's supposed to be a lot of fun. And most important, I want to thank you, folks who have watched this video with us. Thank you for giving Virtual Spring Meeting a chance. Please, until we see you again, be safe and be well.